There we go, folks. Sorry, I'll get this figured out once in a while. Welcome back for our Wednesday edition of Ask a Lawyer Live. Oop, hold on. I got myself on TV there and it's throwing me off. So, welcome back. It's our Wednesday. Sorry, I'll get a smooth intro here at one of these days. It's Dave Brannen, your lawyer. Today is Ask a Lawyer Live, the employment wrongful termination employee rights edition. All righty. I'd like to welcome everyone back. I'll just explain. Let me get my bearings here. I'd like to explain how it works. So if you're new, this is a daily live stream that I do every day. I'm Dave Brannen, disability and employment lawyer. The focus of this stream is for me to give you a presentation on Monday, Tuesday, Wednesday on a different topics, and then we can discuss those topics, and I can also answer any other questions you might have. Our Thursday show tomorrow is going to be our first live call-in show. So you can call in. We'll have the number available on the screen. You can just phone in. That way we can do a more in-depth review of your situation. I can talk back and forth, and I can give you some better advice. Friday is going to be our guest interview day, and I have a great guest who will be on this week. Can't wait to speak to her. And I won't spoil the surprise, but you'll probably be able to see it because it'll be posted online here probably this evening. Now, today's topic is going to be, we're going to talk about dismissal for frustration of contract. This is, in other words, when can an employer fire an employee who is on long-term disability and not have to pay them any severance pay, termination pay, that kind of thing. Now, what I'll ask you to do is that once I get into this talk, just go ahead and leave your comments ask questions by putting them in the comments. Put a Q in front. That way I can know that you have asked a question and are not just making a comment. And I'll answer some of the questions as we go through the presentation, and then I can answer some at the end as well. All right, let's do this. So frustration of contract. Frustration of contract is a common method used by employers to terminate or dismiss employees who are out on long-term disability. Employers like this option because it's a clean way to get rid of an employee who, for good motives or bad motives, without having to pay them any termination pay, severance pay, with some exceptions. But they are often able to avoid having to pay you out termination pay, severance pay, that kind of thing. It is a legal thing that they're allowed to do, and we're going to talk today about when this can happen and what you can do to protect yourself. So, frustration of contract is a legal principle and framework. So, when you hear that word, frustration of contract, think of it as a legal principle that is applied by courts in cases, and it's a way for employers to get out of employment contracts with disabled employees. It essentially allows people in a contract to walk away without obligations. That's why they're able to get out without paying you their obligations to pay termination pay, severance pay. And the legal criteria, there are specific legal criteria in order for a person to walk away from a contract. Now, it doesn't only apply to employment contracts. It can also apply to other types of contracts. But for today, we're focused on employment contracts and long-term disability. These criteria have been set out in case law going back many, many years to England, actually. And so in order for an employer to rely on this doctrine of frustration, they have to be able to establish all of these things. The first thing is there must be an unforeseen change in circumstances. So what that would mean is that in the context of disability, it means that the disability was not foreseeable at the time that they entered into a contract with you. That at the time you were fine, and there was not an idea that this contract would end because of disability. And so the fact that you later become totally disabled and unable to work was something that was unforeseen and not part of the contract. That's number one. The second thing that has to be proven in order for a frustration to take effect is that you must be unable to perform the essential duties of the job. It can't be a situation where things are difficult or hard, It has to be that you're unable to do the job that you were hired to do. You're unable, or at least if you're able to do parts of it, you're not able to do the core parts of it. Okay, even if you're able to do some duties, overall, you're not able to do the job. That's what has to be proven. The third part is there has to be no fault of anyone. So it's not anyone's fault that you're unable to do the job. It's because of things beyond your control or beyond the employer's control. That is another element that must be there in order to claim a frustration of contract. And the final piece here, it must be permanent. So this situation that is causing the frustration has to be a permanent situation, not expected to change or in the near future. So it either needs to be permanent or indefinite, that there's no end in sight of when this might change. So how that works with disability, it means that your incapacity to do the essential duties of your work is a permanent situation and not expected to change. That is something that has to be established in order for a frustration of contract to apply in one of these long-term disability employment situations. All right. So let's think about frustration of contract and dismissal in the context of other types of dismissal. So there are 3 types of dismissal that can happen to someone who is on a long-term disability. Number 1 is anyone can be dismissed without cause. So employers are allowed to terminate employees without cause. That just means there's no reason, you didn't do anything wrong, but for business reasons, they're able to terminate your contract. When the rules and the laws say that if you are going to terminate someone like that, you must pay them their statutory, at the minimum, you must pay the statutory termination pay, sometimes severance pay, based on the laws of your province. And sometimes beyond that, you have to pay common law compensation and things like that. It will just depend on your province and what's stated in your employment contract. But at the bare minimum, if you've been terminated without cause, you're entitled to get the statutory pay provided through your province's Employment Standards Act. That's without cause. For cause termination means that you've done some type of misconduct that allows the employer to terminate you because of your misconduct. And the way the laws are written in all the provinces is that if you have done a certain level of misconduct, employers can fire you and not give you any notice and not owe you any termination pay. All right. Think of things that are quite bad where you've stolen things, maybe assaulted another coworker, given out company secrets, you've embarrassed the company in some big way. Something like that can, if you did it willfully and you intentionally did it, then it allows the company to terminate you without giving you any notice. So in the third situation, you have a frustration situation, and that can arise for a couple of reasons. That not only disability, but disability is a common reason for frustration. For example, another reason we ran across lately was somebody had traveled out of the country, and for whatever reason, they couldn't get their visa renewed to get back into Canada, this type of thing. And so they were being terminated for frustration because they weren't showing back for their job, but they were stuck out of the country. So there was no fault of anyone, pretty much, but they were not able to do the duty. So this was a frustration kind of situation. But most often it's going to be a frustration for disability. And if there's a termination for frustration, in most provinces, you are not entitled to termination pay. However, Ontario and BC have exceptions in their employment standards laws that require employers to pay minimum termination pay to someone who you're letting go for frustration of contract for disability. So just keep that in mind. Ontario and BC have the exceptions. Everywhere else, employers can get rid of you just paying the bare minimum through the Employment Standards Act. Now, even when employers are having to pay the bare minimum through the Employment Standards Act, they're still saving a lot of money because a lot of these employees, they would either have to pay, so a lot of them, they'd have to pay common law notice, which is much, much more beyond the bare minimums required under the Employment Standards Act. So most employers will save a lot of money by terminating employees through frustration of contract. All right. So one good news. So that's the bad news, is that you can be fired in this way, and there's not a lot, it's not your fault. There's not a lot you can do about it. But It's not an easy thing for employers to do. I represent employees, so I'm focused on that. But if I was representing an employer, I would tell them, look, you have to be very careful and well thought out to terminate an employee for frustration. There's a lot of hoops you got to go through, and the law puts a lot of pressure and requirement for the employer to prove things. So just step back for a second. When whoever has when you're in a legal case, you have two different sides in a legal case. The way the law works in Canada, United States, England, one side, when you have two people in court, one side will have the obligation to prove something, and the other side, they can kind of play defense. They don't have to prove anything, but so they could really do nothing. And if the side that has the obligation to prove something doesn't prove it, then they lose the case. So, for example, in a criminal case, it is the government or the crown, as they're called in Canada, or the prosecutor in the United States. The prosecutor or crown prosecutor, they have the obligation to prove you are guilty beyond a reasonable doubt. As the guilty person, or as the person charged with the crime, you don't have to prove anything. That's why people can go to court and not take the stand. They don't testify, which is often the right thing to do. And if the crown prosecutor does not prove beyond a reasonable doubt that you committed the crime, then you get to go off. You're not guilty. So what happens in a civil case, where this would happen if in an employment dispute, it's actually the employer that has to prove that there is a frustration. So if they don't prove it, then there is no frustration. It's important to know that, because whoever has the obligation to prove something in court has the harder job. It's very hard to prove things in court. Things can be true, but you might not be able to prove it in court. That is a conversation I have to have with people all the time. In my books that I've written, I often will say things like the truth doesn't matter. It's what you can prove in court, and proving in court in a way that the court and the judges will accept. So it's not just like proving it anyway. You have to prove it in a way they're going to accept it. So when it comes to frustration, the employer has the obligation, or the burden, as it's called, to prove that there has been a frustration. So what does that mean? Well, it means that they have to prove your incapacity to work. They have to prove that you are incapable of working. Of not working. They have to prove you're incapable of doing the core. Remember, we said the core parts of the job, the essential duties of the job. That they have to prove that. That's not easy for them to prove. Think about the difficult situation they're in. How are they going to prove that? Well, we'll talk about that in a second, but they do have to prove it. So if they can't prove that, then they're not going to be able to rely on this frustration as a way to terminate you. The other thing the employer must prove, so they must prove that you cannot do the essential duties, but that's not enough. They also have to prove that this is a permanent situation, that it's not expected to change. So they might be able to prove that you can't do the duties right now, but if they don't prove that this is permanent or indefinite, then they'll lose. So that's two things they have to prove that are not going to be easy for them to prove. And finally, even if they prove that you have a permanent disability that is preventing you from doing the essential duties, they still have to prove that if they were to give you reasonable accommodations short of undue hardship to them, that you still would not be able to do the job. So in other words, even if they prove that all these things, they still have to show that there's no accommodations they could give you that would allow you to do the job. Very difficult for them to prove. Now, not impossible, obviously, but you will have a lot of employers blunder into this idea of saying a frustration without really establishing the evidence to prove it. And so that can be a big problem for them. So what you can do as the employee, what can you do to challenge or avoid an employer terminating you based on a frustration claim? First of all, just because they're saying it's a frustration doesn't mean that it actually is. A frustration of contract is a legal kind of situation, and it will happen or not happen based on a ruling of law on whether it happened or not. It doesn't matter if someone says it happened or it didn't happen. A court will later kind of be like a Monday morning quarterback and look back and say, okay, yes, the frustration happened and here's when it happened. So it doesn't really matter if they say there is or is not. It's going to come down to whether at law it happened. And for it to happen at law, just like I showed you here a second ago, all of those things have to be true. So for it to happen at law, it has to be unforeseen, essential duties, no fault, and permanent. Those things have to be proven. How you can avoid it, one of the ways to avoid it is maintaining communication with your employer to let them know that you are still working on coming back to work, that you are getting treatment, that you're hopefully going to be getting better. So you can really take away the idea of that it's a permanent disability by staying in touch with the employer and letting them know that you're continuing to do treatment and your doctor's optimistic that things could improve and you might be able to come back at some point. Okay, so that is one of the ways that you can just maintain communication with the employer is helpful. Proving the condition is not permanent. So remember, the employer has to show permanence. You can present evidence because you control a lot of the medical evidence. You won't have total control over it, but you control a lot of the information that the employer has about you. So if you're providing doctor's letters that say that you're improving, that it's not anticipated that this will be permanent forever, that is going to take away their ability to claim that this is a permanent disability for a while anyway. And that is a way you can kind of delay the employer being able to terminate you for a frustration. Now, the other thing is you can prove it's not permanent. You could also have proof that you're able to do the essential duties. Now, that is something, again, that you could have the doctor say that you're able to do the duties or that you will be able to do the duties. That is another way that you can produce evidence to say those kinds of things will prevent the employer from terminating you for a frustration. Now, the problem, obviously, is that producing this kind of evidence also diminishes the strength of your long-term disability claim, because if you're producing evidence that says you're going to get better, that you're going to be able to do the duties, that this is short-term, certainly that will help the long-term disability insurer have evidence to cut you off. So it's not a thing where you can play both sides. You really have to be careful that you don't want to, obviously you need to be honest, but you don't want to overemphasize that you're getting better and that this is not permanent. You don't want to overemphasize that if it's not actually true, because it will hurt your long-term disability claim to be trying to just do this to keep your employer from being able to cut you off your benefits or to terminate you for frustration. Now, there's one exception to this that I want to talk to you about, and I don't want to overplay it, but it also is a way that it's a strategy out there that employees can use to try to prevent a frustration of contract. And that is to prove that the disability itself was contemplated when you entered the employment agreement. So what I mean by contemplated is that if we go back here, you'll remember one of the first principle that it was an unforeseen change. Unforeseen means that it was not foreseeable, that it comes completely out of the blue. No one could have thought that you could be disabled. Well, there are cases in Canada where, too far. There are cases in Canada where courts have said that disability can be foreseeable in other words, if disability is foreseeable when you started this employment contract, then the employer cannot rely on frustration because they will not be able to check off the box that this was an unforeseeable thing. Am I making sense here? So in other words, the court will look into whether it was foreseeable that at the time when you signed this agreement to work for this employer, was it foreseeable to both of you that you could eventually be disabled? Some courts have said if you can prove that it was foreseeable, then they can't later terminate you for frustration because you're off on disability, on long-term disability. So the way that some people have been successful in arguing that it was foreseeable is to say, well, when I signed the employment agreement, it included part of my employment package when I was hired of all the benefits was long-term disability benefits and these sick leave benefits. So obviously sick leave and long-term disability was foreseeable when we did this contract, because I have the long-term disability benefits, which are there for people who are unable to work for long because of long-term disability, right? See how that logic goes? That has, in a couple of cases in Canada, been accepted. Okay. So that has been accepted. There have been courts that have held that if you can prove that it was foreseeable, the fact that you had long-term disability benefits was pretty good evidence of that, then the employer cannot rely on frustration. Now, other courts in Canada have said, no, that goes way too far. You cannot lock an employment for life. And they will say, they won't go so far to say that you can't claim frustration as an employer, but the presence of long-term disability benefits will make it harder and longer for the employer to say that the frustration has now happened. So it extends the time that you would get before an employer could successfully say there's been frustrated. Now, you may ask, like, well, how is that? Isn't the law the law? A lot of people think the law is black and white. The law is not black and white. It's actually kind of complicated sometimes to figure out what the law is. And you don't find out what the law is until after the fact. When you go to court and then they say, oh, this is what the law is. Well, like, it wouldn't have been good to know that before. But yeah, that is how it works in Canada, in countries with common law, like the Canada, the US, Britain, Australia, and other countries like that. So it is not always knowable in advance what the actual law is. You can predict, you can try to make this, you can kind of predict what it would be, but this is a situation where the law isn't clear because there are different courts taking different decisions. Now, the way the court in common law countries, the way it works is that there is a rule that a court has to follow. If a court above them, a higher level court, has made a decision on an area of law and has made a ruling, that the lower courts have to follow it. So the higher courts would be like the courts of appeal in each province, or the ultimate court would be the Supreme Court of Canada. Now, the Supreme Court of Canada has not ruled on this, and apart from, I think, the Court of Appeal in Newfoundland, not a lot of Court of Appeals have ruled on this issue of does having long-term disability benefits as part of your employment contract mean that the employer cannot claim frustration. I believe, I was doing my research again today to look at it, I think the Newfoundland Court of Appeal is the only one that has accepted that idea. It's just not gone to the other courts. So it's not that they've rejected it, they just have not dealt with it. And you then have a series of other when lower courts don't have a higher court ruling on an issue, they can go all over the place. So that's what's called unsettled law. When you have a bunch of lower courts just going their own way, making different rulings, what will happen over time is you'll get enough of these court decisions going all over the place, and the Court of Appeal will accept a case to go on appeal to try to pick, okay, here's what we're going to do. You've got all these cases saying this, you got all these cases saying that. The Court of Appeal can choose to go with these cases, and now that will become the law going forward, and all lower courts have to follow it. Now, what happens is, if you get a bunch of courts of appeal in different provinces, each province only has one court of appeal. If they all start making different decisions at a certain point, the Supreme Court of Canada will say, okay, we'll take this on and we'll decide to go with these courts of appeal over here, and we're going to reject what these courts were doing. And now going forward, all the courts of appeal have to follow that. So that's what we need there, but that isn't there right now. So it is open to argue that if you have long-term disability benefits, that you can't be frustrated. Now, it's not a strong argument. I think that the way this will probably go is that courts will eventually land on this bottom one here, that having a long-term disability policy is part of your employment package when you were hired. That will probably just extend the time for a finding of frustration and not rule it out completely. But you never know. The first time I really became aware that there was this idea that you could have that frustration might not be possible, it was when I just happened to be reading this book here. This is one of these red books you see behind me on the wall. These are Halsbury's Laws of Canada. So this is it's kind of old school because it's written, it's like paper, but a lot of this stuff's online now. But what these red books behind me, what those are is Halsbury is just a company that hires well-known lawyers, well-respected lawyers in their areas to summarize the law around all the different areas in Canada. So, for example, this book here just summarizes the law of employment in Canada. And it was notable that in here, the person who summarized the law around this area did say that basically held that, let me find their actual, I'll just read it to you. If the employee is entitled to and in receipt of long-term disability benefits under his or her employment contract that cover his or her sickness or disability, it's quite a long sentence here, the doctrine of frustration is inapplicable because the parties will have foreseen the alleged frustrating event and will have allocated its risk accordingly. Indeed, it would appear to fly in the face of the parties' factual intentions if the employer could release a sick or disabled employee and deprive him or her of those very benefits by arguing the employment contract has been frustrated. So that is that's a statement of law from the author who authored this version of the Halsbury's laws on employment. And again, it doesn't mean that that's the law, that law will be accepted in Canada, but it does show that there is some pretty strong support for the idea that in some scenarios, possibly, you could have an employer not be able to rely on frustration. So what does it mean? What happens if an employer fires you for frustration, but then it's later determined that, okay, there was no frustration or the frustration has not happened yet? Well, that means they've just fired you without giving you notice, and you're entitled to statutory termination pay or severance pay based on your provincial Employment Standards Act or equivalent. And also, depending on the wording of your contract, you may be entitled to common law severance and termination pay above and beyond the bare minimums that would be provided in the Employment Standards Act. So it's essentially a wrongful dismissal lawsuit or claim, and you'd be going after them for proper notice. And notice and termination pay is determined based on a bunch of factors, the most important of which usually include your age, how long you were employed, and the type of job you did, how much you earned, how difficult it would be for you to find alternative work. And based on all those factors, you can be entitled to quite a bit. So, like, for example, you might only be entitled to, like, most of these will cap out. Like, for example, in Nova Scotia, I think it caps out at 8 weeks off the top of my head. I think the most termination pay in most provinces, it will cap out at about 8 weeks. But someone who is, in their 50s or 60s, who's worked somewhere for 20 years, they might be entitled to like 16 to 20 months of common law severance, whereas they're only entitled to 8 weeks under these employment standards. So see the big difference here? That's very important. So that's why I encourage people who have been terminated for frustration to get legal advice and to really look it over to see legally, is the employer going to be able to prove there was a frustration? Now, why wouldn't they be able to prove it? Well, if there's ambiguous evidence, around your disability, then they're going to have problems proving it. Sometimes they just don't have the evidence. But a smart employer will try to get the evidence, and they will usually get it by getting your doctor to fill out medical updates. So your employer gets medical updates that forces the doctor to say whether this is permanent or not. So that's how they create the evidence, is by getting your doctor to fill out forms that force the doctor to make comments on these frustration kind of principles. You as the employee have to cooperate with that. You can't claim that they didn't prove frustration if you prevent them from getting evidence and getting information from your doctors. So that is something that you do have to do. The other thing is, apart from proving the frustration, they also have to show that you can't be accommodated under the human rights legislation. And you also have to cooperate with that. So you have to cooperate with the employer's efforts to assess whether you could be accommodated under the human rights laws. So just keep that in mind. All right, so that's the end of this. I'll be happy to take questions on it if people have questions about it in their own situation. We had some questions yesterday. Unfortunately, I can't see those comments right off the top of my head. So hopefully those people are back here today and we can go through some of the questions they had around this topic. You can put whether you're watching this live or watching it afterwards, you can always put questions down in the comments and we'll monitor that. If you put questions while we're live here, I can answer them right now. Also, if you are in a situation like this and you are not certain, you can always contact us or another law firm for a free consultation on this type of issue. Okay, let's go here. So let's go to some live questions if we have any. And it looks like we do. So let's start off here. Okay, so this is a question from Jason. Would I get cut off long-term disability if I tried to go back to work? So this would be a situation where someone is off on long-term disability and are thinking about trying to go back to work, and they want to know, would I get cut off the LTD if they try to go back to work? So yes, ultimately, long-term disability will stop at some point if you're trying to go back to work. However, what most long-term disability insurers will do is give you a bridge. They will bridge you over a period where they might, based on what you're earning from work, they will kind of top up the payments. That is not a permanent situation. They will usually arbitrarily say that we'll do this for like 6 weeks or something like that. And often they're quite inflexible about it. So they'll say, we'll do it for the next 6 weeks. You're like, oh, wait a minute, my employment got delayed. There's this and that. It doesn't matter. We're doing it like, so they can be very inflexible about it, but they will usually offer some type of a bridge where they will top up your pay. So if you were trying to work and you could add to, like, a common thing is when people return to work, they start at lower hours and work themselves up to working full time again. Not everybody has to do that, but that's a common way for people to reintegrate back into the workforce. It's called a graduated or a gradual return to work. And during the gradual return to work over, let's say 6 weeks or 8 weeks or whatever it is, the employer will usually be only paying you if you're working part-time. You'll only get paid part-time. So the disability insurer will top you up for that period. Sometimes what insurers will do, they'll say, okay, great. You want to go back. We've figured out that you should take 8 weeks arbitrarily. It often has no real basis in any kind of fact. They'll just say, we think it'll take you 8 weeks. So we're just going to give you 8 weeks of benefits and then you're done. And you'll be like, whoa, wait a minute. So it could be jarring like that. They could just pay you 8 weeks of benefits and say, that's your time to try to get other work. And if you don't have other work at the end of that, well, we're cutting you off. So it is possible that you will be cut off. Quite honestly, it'll be quite common to be cut off if you start to go back to work. Now, if you go back to work and fail, it doesn't work, pardon the pun here, it doesn't work out, or you're not successful. If you're not successful because of your disability, either you overestimated your ability to work or the disability got worse again and you are now incapable again, you can go back on long-term disability. Now, the insurer may not willingly want to do it. They may not agree right away to just put you back on benefits, but that's when you can do appeals, sue them if you need to, that kind of thing. But the way most policies are written, if you make an attempt to go back to work and it fails within 6 months, then you go back on the same claim, right back onto the same claim. So it's like you don't have to start over from scratch type of thing. All right. Thanks for that question, Jason. That was great. Let's see what else we got here. All right. This person says, I have Sun Life insurance with my employer, then quit. Does that mean I will never able to be buy or have health insurance again? No, it will not. If you have group benefits through an employer, medical plan, and this type of thing, when you quit, it just means you're no longer insurable under the plan that employer had because you're no longer an employee. It doesn't mean you'd be barred from getting insurance from that. Like if that Sun Life had benefits with another company, it would be a different policy. So each company has its own insurance policy directly with Sun Life or Manulife or whatever company they're going with. And if you go to a different company, it will be a wholly different, even though it's the same insurance company, it will be a different policy, right? So it would be completely different. The only time you're ever limited to not getting insurance again is Sometimes when you do a settlement, like if you sue, let's say you do a lawsuit against an insurance company like Sun Life, and I'm just using them as an example here, but sometimes if you do a lawsuit, part of the settlement of the lawsuit might be that you will never make another claim again under this policy. So that will mean if for whatever reason after the settlement you ever got back to work with the same employer, you wouldn't be able to make another claim under this policy. And some insurers, I'm not saying Sun Life in particular, but some insurers will try to also negotiate that not only will you never be able to make another claim under this policy, but also any other policy with any other employer. But those are things that would have to be included in a settlement if you were doing like a lump sum settlement over a denied disability claim with an insurer. And that can include, like, sometimes these settlements will say no long-term disability claim again, or sometimes they'll say any type of claim. So you have to be those are things you're negotiating and have your lawyer be very cognizant of, aware of when you're negotiating these types of settlements. Okay, let's see what else we got here. Okay, so this person here is off work on WCB, watching live. My work keeps wanting to challenge my workers' comp. Also said they can't accommodate a gradual return to work. Okay, this person's got PTSD, depression, and these types of things. And there's a few other comments here. I'll just see if they. Yeah, so they're worried. They're worried that they may accommodate just enough to fire me. That's a concern that people have. And wanting to know, I guess what I'm asking is, can my work a gradual return to work? Can my work? So I guess what they're saying is, here we go. Can my work refuse a gradual return to work? So this person's wanting to know, what if workers' comp, they get mixed messages. So often employees can get mixed messages. So for example, this person's saying workers' comp is pushing for a gradual return to work, but the employer is saying no. So when you get into that type of situation, that is a common thing that can happen with workers' comp or with long-term disability as well. There can be disagreements. Like the insurer can be saying, yes, you want to do it, and the employer can refuse to take you back. That is a difficult spot to be in. It's different depending on whether if it's with workers' comp, they have more pressure on an employer to take you back if it's workers' comp. So they can get directly involved with the employer to kind of force the employer to a certain extent to allow you to do this. With insurance companies, they can't really force an employer to take you back. They don't have the same kind of powers as workers' comp does. So, that's basically the situation you're in. If ultimately what you need to do is just be open to doing the return to work and indicate your willingness to try it, especially if it's workers' comp. If you refuse with workers' comp to do a return to work, then they can just stop your benefits and they don't have to pay you anything just based on the refusal. Same thing with long-term disability. A refusal to do a return to work is grounds for them to stop your benefits and pay you regardless of whether you're disabled or not. So you have to be very careful about these refusals. I do cover it in my book back there. You can see it on the wall. Where is it? Right there. This book here. That book has a whole chapter in there on it. Well, not a whole chapter, but a section of a chapter that talks about how you have to be very careful and how to manage these return to works and refusals. So I don't know if that totally answers your question or not. I guess what you need to do is act in good. You have to just make it known to workers' comp that you're willing to try this. That way, they're not going to hold it against you. They will hold it against the employer and go after them. If this is someone watching and you're more dealing with a workers' comp situation, you're dealing with a long-term disability insurance situation, then it could be deemed as a wrongful termination. In both situations, actually, it could be their refusal to allow you to try a return to work, the employer's refusal, that could be a constructive dismissal or an actual dismissal, could open them up to a human rights complaint because they're potentially failing to accommodate a disability. So that gives you those types of options as well. But ultimately, like, you can't control what an employer will do. Is if they refuse these kind of things, it will have to be determined whether they could be correct. Like, maybe the insurance and workers' comp is pushing you to do a return to work, but it's not realistic. So if it turns out the employer is correct, then it will be a situation where you should remain on disability benefits and not be forced into return to work. All right, here's another question. This one says, can I go back to work and then fail and then go back on LTD? Yes, that is absolutely can happen. So you can, it's always best. And I indicated in my book over there that you can get it all backwards. This book right here, I do indicate in that book, I talk about the most important thing for you is to go along with the return to work in good faith and do as much of it as you can and show that you gave a good faith effort. If you can do that, then it's much easier to get approved to go back on benefits again if it fails. And so that's the most important thing, is to prove that you gave it an honest, good effort and you went along with it as far as you could. What I don't like to see is when people just refuse it outright. Even if you know, like, you're not going to be able to do it, it's better to just go along with the process to gain more information. So instead of just refusing right off the bat, say, okay, no, like, let's get more information. Let's get a rehabilitation coordinator in place. So you ask the insurer to put that in place. Let's have them talk to my doctor. So you get a lot more information. That way, if you and your doctor say, no, look, this is just not going to work, you can show that you engaged in the process of it and got more information. The problem with just outright refusing is that later on, it's very hard to justify that if you're in before a judge, and the judge will say, well, your doctor said, yeah, I told them not to do it. And the, the lawyer will cross-examine your doctor and say, well, did you know that they were going to allow them to come back one day a week? Well, no, I didn't know that. Did you know they were going to have, like, they can say the most ridiculous things that maybe were never going to be true, but they can put those things to the doctor and say, well, if you'd have known that, would you have allowed it to go forward? And now the doctor will, like, flip and say, well, yeah, I guess if I'd have known that, yeah, I would have agreed. So now they will flip your doctor around, and these doctors will flip. Doctors don't like being under pressure. They're trying to help you out, and there'll be things like this they didn't consider. And not every doctor will flip like this, but a lot of them will, because it's very hard. You look foolish to say, I wouldn't have agreed to this if all these amazing accommodations had been in place. There's some doctors will stick to their guns and say, I don't think so, but they may look unreasonable in doing so. What won't be a problem is if before the judge, the doctor says, yeah, like, we explored it. I spoke with the rehabilitation coordinator. I got all these details with this and that. And then we decided, after having all that information, to not go forward with it. That way, I don't want to beat a dead horse here, but that way, by engaging the process, think of it this way. By engaging in the process, you lock down what the facts are of what was offered, so that later on, the employer and the insurer can't come up with these ridiculous things to say that they would have done that they actually never would have done, but you have no way of disproving that. So you want to lock in the details of what this is going to look like. Then you can make an informed decision to refuse it or not. But if you don't lock in the details of it, what will happen is later on, they'll just come up with all these ridiculous things that they probably never would have agreed to, but you have no way of proving they wouldn't have done that. And so now you're the one that looks like you weren't willing to try. All right. Now, another part to just answer this in the second part. Can I go back to work and fail and then go back on LTD? So the second part of this is, how long are you back to work? If you go back to work long enough, you will not be able to go back on the same LTD claim. This is this idea called recurrence of disability. So once you go back to work from being on a disability claim, most policies will have specific wording about a reoccurrence of disability. So in other words, if you go back to work and you have to go back off work again because of the disability within a certain time period, it will automatically go back to your same claim. Usually that is 6 months, but there's very different wording about this. So you always have to read your own insurance policy to see how it's worded. But a common period of time is 6 months. So in other words, if you return to work and within 6 months you're off again, because of the same disability, then it would go back to the same LTD claim. Where people can run into problems is, let's say you go back to work, but with a different employer. So you're no longer employed with the same employer as before. LTD will cover you if you're not with the same employer. So let's just say a situation where someone lost their job, was fired or whatever. For whatever reason, they're no longer employed with the employer they had the insurance through, but their LTD claim is still going on. They try to go back to work with another employer. Well, if you go back more than 6 months, which is a common period of time, you will now be past the reoccurrence period and you will not be able to make another claim. You would have to make a new claim, but a new claim would have to be through any insurance that your new employer might have. Maybe your new employer doesn't have long-term disability insurance. You don't have that through them. So you would be out of luck completely. So another thing to worry about when you are doing these returns to work is you have to, if you're going to fail at it, make sure you fail quickly within. So don't hang on and then figure out on 1 day past or 1 hour past the 6-month time period that, oh, this is not going to work. Figure that out beforehand. Don't put yourself in that position. I had a case early in my career where a thing like this happened, and we were like literally working out the minutes to see, is it, because these deadlines go right down to the minute. So you're trying to figure out, was he on, and it was just such a roller coaster because I would have it figured out that he was, and then I'd be, oh no, he's not. And yeah, you have to be very careful about that. All right. Any other questions in the meantime? I can take questions if it's not specifically around frustration of contract. If you have other questions, I'm happy to try to answer them for you. If it's not dealing with employment and disability law, you might be up the creek. I'm not, those are my main areas that I've worked in for like 20 years. My family get frustrated because they'll call me to say, yeah, David, can you actually do our will? And I'm like, Dad, no, I had to hire my own lawyer to do a will. I'm so hyper specialized that I have not even looked at doing wills since law school. So completely not competent to do a will. And unfortunately on TV, they usually portray lawyers as like knowing all areas of the law, which is completely untrue. Most lawyers are focused on one, two areas and get really good at it. And it's very hard to stay on top of everything. It's very impossible. In fact, if you want a miserable career as a lawyer, you will work where you're faced with new legal things every day and don't have any expertise, and you're constantly researching and trying to figure out what the law is on this thing. That is a very stressful way to live. So I don't recommend it. If any of you you're thinking of going to law school or becoming a lawyer or have children, then tell them to pick an area and get good at it, an area that they like. All right, folks, it looks like we got all the questions answered today. So we'll be back tomorrow with our call-in show. I don't know if we'll have some shy people who don't want to come on the call live. Now, it will be a phone call, so your face won't be on the screen. You won't have your name's not going to be showing or anything like that. But I would encourage you to, I'd also encourage you to not to say things that you don't. This is a public forum, but it is helpful to do a more in detailed conversation and give you better detailed advice. It's easier than kind of going back and forth these comments. It's hard to express yourself. So if you have a more complex issue that you want to talk through, tomorrow's the time to do it. How you do it is just show up at the same time. It'll be 4 p.m. Atlantic, 3 p.m. Eastern, like we did today. The phone number to call in will just be scrolling along the bottom of the screen. You just have to phone in. You'll be put in a queue, and then I'll just answer the calls one by one. And that's it. So thank you all for showing up today. I will see you back here tomorrow and see you back here Friday. And then on Monday again, I'm going to keep doing these every day. So far, it's been going good. I didn't know if I'd be able to, how good I would do at the end of the day here, because I'm usually pretty tired by 4 o'clock, but these have, there's not been a problem with me staying awake and doing these at all. So let's just hope that continues. That's it. Take care, folks. We'll see you here tomorrow. Bye-bye.